So here in the United States, you can file a trademark application as an intent to use application or a use application. And that's just what it sounds like. If you're intending to use the mark on particular goods and services, you'd file the application and let them know that you intend to use them. If you're actually using the mark on actual goods and services in interstate commerce, you'd identify the first date of use and the first date of use in interstate commerce that you've used the mark on those goods or services. Now I'm going to talk to you briefly about the timeline of a U.S. application. Once you file a trademark application, in 3 months it's assigned to a trademark examining attorney at the USPTO. Once that USPTO examiner gets that application, they're going to look for informalities. Did you pay the fee? Are the identifications accurate? Is the mark filed properly? Is the owner identified? Essentially, they're looking to make sure that the application was filed correctly. Once they examine the application for informalities, then they plan to do a search. They're going to use a resource that you have access to, uspto.gov. You can go there and search your mark prior to filing to ensure that there's no other marks out there that are likely to cause confusion. Now, the standard for trademark registration is a likelihood of confusion. So the question is, are there other marks that are likely to cause confusion with your mark? So if there's a mark that's filed prior or a mark that's registered, essentially you may not be able to get that federal trademark. Now, more than one person can own the same name for a trademark. So my name can be Evans IP Law for a law firm, and your name could be Evans IP Law for a shoe company, because the public wouldn't necessarily perceive a shoe company and a law firm to be owned by the same entity. Now, the next thing that you want to think about when you think about a likelihood of confusion is the commercial impression of the marks. Do they sound the same? Do they look the same? Do they have the same meaning? Does it mean something in a foreign language that translates into a meaning of a word in English that's already trademarked? These are things that you want to think about and consider before you file an application. Now, when that trademark examining attorney does that search on uspto.gov and they're looking to see if there are marks that are confusingly similar, if they find that, you'll be issued an office action, and then you'll be given 6 months to respond to that office action. So you want to make sure that you're working with a qualified attorney to help you articulate arguments to show why your application and your mark does not cause any confusion. Provided that you can persuade them, then the mark is published in the official gazette for third parties to challenge. At that time, someone in the public who may perceive your mark as causing confusion or have an issue with your mark can then challenge you for 30 days. Provided they don't challenge you, then the mark will register. Now, once you get a trademark registration, keep in mind that it's up to you to police and enforce your trademark applications.